I've got to switch computers, just so you know.
Okay, that's fine.
Everything is on the other system.
Okay.
And nothing has popped up, just so you know.
Okay. All right, welcome everybody. We are going through a little bit of technical stuff, but for right now, I'm going to go ahead and introduce Jonathan Graham. The topic today is Legacy Trustee Services, a corporate trustee alternative. And thank you for your patience. We're just going to do a couple little things real quick, and then we'll begin the presentation. I'm going to go ahead and remove you and then bring you back and see if it'll bring in the where it allows you to show it. Okay. Does that bring any other settings in there?
I didn't even see myself remove. How about I just check out and come back in?
Yeah, let's go ahead and try that. Bring any other options along the bottom there to you.
It did not. Let me go to the other system then.
Okay. I just wanted to take a second and thank everybody for their patience. It should only be a couple more minutes.
right, can you hear me?
Yes, I can.
All right, so I'll just get started right now. Is that fine?
Yeah, that's perfect.
Hello, everybody. Welcome. Sorry about the little bit of technical issues we're having there. So my name is Attorney John Graham, and I am the founder and president of Legacy Trustee Services. So what I'm going to be doing today is I'm going to be going over, once I get to the right screen, what's going on here? We're going to be going over how Legacy works and also how how it, as a corporate trustee, how they could be different and work with your clients in helping you move through other different type of issues that you have. So now I'm having, no.
Is it letting you present? Does it have?
not
Okay.
letting me share my screen.
I'm going to go ahead and add Jeff. He's kind of the guru of this, so
Hi, Jeff.
he can help walk us through this.
Okay, there should be a little button down at the bottom, present, and then
Yep.
it will have you upload your slides. Have you done that?
You want to upload the slides? Okay, we can do that.
Yeah.
That's fine.
Okay, and then once that's uploaded and you've kind of got the slides and you put them into the studio, that's when you can toggle back and forth between your image, the three of us, just you.
It's telling me it's too large.
Hey.
So, and there's not a way for me to share my screen through this system?
If you click on the present button and you try the bottom one that's on that list that says share screen, does it do anything?
It will not allow me to do that.
Oh. If you want, you can email it to me and I can just follow through and see if it'll let me do it.
Yeah. Well, it's larger. That's part of the problem why it won't upload. So
I'll let you then.
let me just try PowerPoint, upload files. Yep. So that's too big. So I know what we'll do. We'll go like this. Just give me a moment. I'm going to edit out 2 slides. I think that will help.
Okay.
Sorry, it's trying to make me save it to OneDrive and not onto the same exact place that I already had the slide in. All right, let's try that again. All right, it says it's processing. All right, so hello everybody, and thank you for the technical problems, and welcome to the Estate Planning Sources Educational Seminar. This month we're going to be talking about Legacy Trustee Services and Estate and Administration, and kind of going through how a corporate trustee, smaller version, we call us a non-brick and mortar type of version of a trustee services, and how they can help you and also help your clients. So a little bit about me. I'm attorney Jonathan Graham, president and founder of Legacy Trustee Services. Legacy and Trustee Services has been around for around 10 years now, helping different parties with trustee and we'll say administration services. And we'll go through what type of clients we work with. I am a practicing attorney, but I actually formulated this company about 10 years ago because I saw a major need inside the estate planning field, that which there are people, companies, entities that need this type of service, and we'll go through different reasons about them. I am also the Dean of Education of the National Institute of Certified Estate Planners. They have a partnership program with the Estate Planning Source. NICEP is one of the foremost professional educational estate planning certifications in the country. We have the CEP, which stands for the Certified Estate Planner, and the Master Certified Estate Planner designations. Both of these are recognized by multiple broker-dealers and other type of financial agencies so that you can use them as part of your accreditation in continuing forward in your education and what you can provide to your clients as tools and resources, and also as a designation that actually has a full value in worth of it. So now let's talk a little bit about Legacy Trustee Services. Again, we've been in business for about 10 years. We have over 150 clients. Our business is national. It's not just a local trustee service company. And we have clients all over the country who we may help service their more complex trustee needs, and who we can help bypass any of the larger type of trustee service issues that you have. So first of all, who are we not? Well, Legacy Trustee Services is not a big bank, or as we like to say, a brick and mortar type of institution. Those are other types of alternatives that are out there that you can use. Large organizations such as, Bank of America, TD Bank, other types of large national banks that have these type of services that are available to you, Chase service. The other type of organization we are not is, even though I am an attorney, we are not a law firm. A lot of times attorneys will use alternatives such as banks or third parties instead of being a successor trustee or primary trustee inside of any trust or estate plan. I get a routine question from a lot of clients of mine or clients from other people: why don't I just make myself individually a trustee? Because as being an attorney, I have the ability and the flexibility to do that. Well, the answer to that is it is a large disservice to the client themselves. If I make myself individually a trustee for an estate plan and I die, which I hope doesn't happen, right? I'm not looking for that to occur. But if it does, because as we all know, we cannot plan on when our own demise is going to be, then I have put that client in a major disservice situation. In other words, they may or may not update their estate planning documents to reflect my death. Additionally, I may be in the middle of administering an estate plan for them, and my death may cause major issues and holes or gaps inside the services that are needed to be provided to the beneficiaries of that estate. So therefore, with legacy, if I pass away, there's a continuation of all services provided. There are other personnel inside the corporation who will continue on without me, how sad they may be. And there is a line of succession on how the company will be managed after my death. So in Legacy Trustee Services, we take a more personal approach. We don't take the large, big bank brick and mortar where, you've got a different case manager maybe every 6 months, where we're not taking individual family dynamics into consideration in planning for those individuals based upon what the grantor / settler of the estate plan has decided to create. We're taking a lot of the individual creator of the estate plan's wishes into account in non-documented form. We are a strong proponent of, in situations where there are HEMS clauses or other discretionary abilities of a administrator of an estate, may they be an executor or a trustee, that the creator of the estate provide in-depth precatory letters, providing instructions on how that person or persons wants their estate to be managed and how those assets are used for beneficiaries throughout their entire lives. So with that personal approach, we're able to take a lot more and move forward with those clients and be able to understand their wants and needs so we can fill what the creator wanted for them and also what the beneficiary wanted, and try to fulfill the needs of the beneficiary with the intentions of the creator of the estate. We take a much different approach than the bigger brick and mortar type of corporate trustees. We have free pre-death meetings with all of our clients to review their status and wishes. So if you are a Legacy Trustee Services client, you're not paying for those individual meetings that you typically or routinely would have had. Again, we encourage precatory letters. Even during those meetings, drafting some of those up. A lot of times, we like to send people home and let them draft them up themselves and think about them. But if you need something in a rush, having them in that meeting and being able to have it is very important. After death, or even if we're running a trust during someone's life of the creator, we have at least annual meetings. Usually it's far more frequent than that. I would say quarterly is probably the least amount of meetings we have with beneficiaries after the death of the creator. And these meetings are designed to keep us apprised of how that beneficiary is doing, how the assets of that estate plan are working for that beneficiary, and are we accomplishing the goal of the creator of the estate plan in order to make sure that that beneficiary is getting the most out of those assets as the creator wanted them to get them for, and to. We have a team approach with keeping the financial planner and attorney client retentions. Our job is not like a lot of big brick and mortar banks or other third-party trustee companies where you must change the ownership or the investments directly to the third-party corporate trustee. Legacy Trustee Services does not do any financial investing or holding of financial assets. Our job is strictly to be the trustee, or in some instances, the administrator of the estate. We keep in place the attorney for the estate, the financial planner of the estate, and if it's necessary, the additional financial team, and which can include CPA and tax preparers. This is very important because it keeps the continuity and the fluidity of the estate moving without many gaps. And who knows better what the creator of that estate wants than the people who helped get them there. So let's review how Legacy can help your clients. Well, we have disbursement services, okay? We help with the actual disbursements of revocable living trusts and wills when they come in at that point. So we may be sitting there for years doing nothing inside of an estate, maybe doing some routine checkups for someone, but until that person passes away, our services don't start. Why would someone choose to use a third-party trustee? Well, they may have children that are fighting. And I will tell you through my own practice, post-COVID-19 2020, I have seen more family issues with people disassociating themselves either with their parents or with their siblings than I did pre-2020. It's a new disturbing trend that has really been expounded from COVID-19 or maybe other social factors that I'm not taking into account. I just know the timeline of where that has exploded. It was rarely prior to 2020, rarely did I meet with a parent who had a disassociation with their children. It happened, but it was rare, okay? The frequency of me meeting with parents who no longer talk to their children, who are disassociated with their children, is far more common than it has ever been. And if children are having issues with their parents and are disassociated with them, I will tell you that also with sibling to sibling, there is a greater frequency of children not getting along. And that is where you would bring in a third-party trustee. That way, the children, you don't have to pick through quarreling children. You can have a third-party trustee come in, run the estate. The children want to get mad at anybody, they can get mad at Legacy Trustee Services because they don't like the way things are going, which they're going to be following what their parents are. It keeps down the negativity inside of the estate and allows things to go a lot smoother with a lot less of contesting of the estate. Another example of someone who may use Legacy Trustee Services is someone without a family. You know, they may not have any immediate children or immediate family, or maybe their family is of similar age and they're not sure if they're going to be around. So they want to have a person or management in place so if anything happens to them, they make sure that they're there, okay? You could have unqualified children, children with dependency issues, children who don't run finances very well, children who are not diligent, okay? If you have unqualified children, then that could be a problem. The example I always love to give to people is earlier in my career, I was meeting with a couple about the successor trustee of their revocable living trust. We're going over all the different facets. We get to successor trustee. We start the discussion with that. And the mother looks at the father and says, well, I guess Joey now can be the trustee of the trust. And the father looked at her and said, yeah, you're right. He now can be trustee of the trust. And me sitting at the table and being the person I am, I looked at him and I said, So what's changed in Joey's life that he can now be the successor trustee? Well, the dad looks at me, Joey just got out of jail. But we figured since Joey's the oldest child, he is the one who would be able to be the best person to be in charge. No. Joey's not the best person to be in charge, probably. Okay? I'm not trying him again, but that family had 2 other children. The second child was a nurse. The third child was a CPA. They were in better positions to be in the positions of making medical and or financial decisions than probably Joey. But many of times you can see that the creator of an estate plan may not have qualified children in their own estimate too that they believe can do the job. Another reason why someone may choose a third-party trustee is they don't want to pass the burden on to that person. So again, passing the burden on is a very broad example or a broad explanation. If I have 2 children are fighting and I give one of the children the administrative powers of the estate, I haven't just given them the burden of collecting the entire estate, making sure all the bills are paid, making sure the assets are liquidated at top value. I've also given them the burden of arguing and working with their sibling that they don't get along with, okay? If I'm in the situation where there's no family, the burden is how much financial information am I going to share with that person? If I'm going to give it to my brother, my niece, my nephew, if I don't have any children immediately that I want to put in charge, how much financial information am I going to really share with them? And if I'm not going to share a lot of financial information with them, then haven't I just increased that burden? Now they've got to go looking for all the assets. They got to go looking for passwords to my phone, my computer, my Amazon account, my Netflix account, whatever I have that's out there. They have a heavy burden to go to all those and then turn them off. Okay? On top of doing all the regular things and also including filing final tax returns. And if there are estate tax returns, dealing with those. So passing the burden cannot just be doing the actual checklist of things you have to do whenever you are shutting down or dispersing of an estate, but also in dealing with other parts of the estate. Okay? The other reason why someone may want to choose it is because of a charitable beneficiary. They may not be allowed to be the trustee of the trust under charitable trust rules. And with a charitable beneficiary, they may not be able to have a family member being the trustee of the trust. Okay? And the last reason, right, is purely qualifications and efficiency. They may believe they've got the greatest children in the world who will do their best effort, who get along great, who know all of the personal issues of the parents, all of the assets and everything that's there. But how many times, if you're not in this industry, are you actually settling an estate in your life? Once, twice, maybe 3 or 4 times? The efficiency of how quickly an estate can be settled, and actually the lower fees because it's done by a predetermined amount of money or a predetermined percentage, can actually make an estate, if you appoint a corporate trustee, far more efficient, far quicker, and cost a lot less money. Additionally, if you're looking at hiring a third-party trustee, they are going to be more in tune and more in line on state and potentially federal estate taxes. I'm not sure if you're one of the people here on the right-hand side who has that bumper sticker on their car. I love taxes, right? But every person I work with doesn't want to go around taxes, but they want to maximize all of their exemptions and minimize the taxes according to the Internal Revenue Code. A qualified third-party trustee is going to know how to do this, know how to organize it, how to carry it forward. This is a very important part of third-party trustees. In these situations, you'll typically have a revocable living trust. It doesn't have to be. And another facet to strongly think about is that in 2025, the current federal estate tax will be sunsetting. What are they going to do with it? I don't know. No one knows, right? There really hasn't been a lot of conversation. There's been some stuff bantered around, but there hasn't been enough that I can conclusively say is moving in a specific direction. And depending on how the elections come out in November, that thing may just sunset if you have gridlock down or out in DC. So planning with corporate trustees or third-party trustees will help eliminate, minimize, and reduce any taxes, may they be estate, capital gains, income, any type of taxes you want to look at. Income in respect of decedents, IRDs, whatever, you would want to have a qualified third-party trustee to review these. Another example of estates that you may also want to have would be third-party trustees, would be for ILITs. And again, ILITs fall under taxes, or Medicaid, right? Legacy Trustee Services or a third-party trustee is going to work and protect your assets from overtaxation or not maximizing exemptions that you have. And with Medicaid, you can look at with different trusts that you can use Medicaid and third-party trustees to create that next level of insulation for your clients. When reviewing irrevocable life insurance trusts or ILITs, also remember there are different types of ILITs. Okay? The most common irrevocable life insurance trust is where you have a joint trust between two spouses. They have a second to die life insurance policy. That policy is in that trust. You're paying premiums, right? You're doing the crummy letters. You're paying the premiums. You're getting the bills out so everybody pays their life insurance, okay? Okay? When the first person passes away, things keep going, okay? When the second person passes away, that irrevocable life insurance trust is then used to either distribute to the kids or pay estate taxes based on the net value of the estate. Okay? In these situations, corporate or third-party trustees, such as Legacy Trustee Services, are strongly recommended. Like I said, there are multiple provisions you have to do every year in order to protect that asset as a separate asset of the decedent's estate. You have to collect the premiums. You have to issue the crummy letters. The crummy letters either need to be collected with a waiver of the gift, or that gift period needs to expire. Then you must pay the premium to the life insurance policy. This should all be done in a bank account set up under the name of the trust and a third-party trustee. If you're not doing any of those things and you're not accounting for them, when the estate tax man comes up and knocks on the door, that asset, that life insurance that your client was counting on being outside of their estate taxable estate will become part of their taxable estate, and now there will be much higher fees that are due. But let's talk about a different type of ILET, a spousal HEMS ILET. Now, a lot of people are aware of this, but not everybody is as of the moment. This is a great protection or estate planning mechanism that the estate planning source uses in order to protect each spouse. How do these work? Well, I've got an ILET for each spouse. One for the husband, one for the wife, we'll say. There is a third-party trustee in charge of each of these trusts. When the husband, we'll say he passes away first, because us guys have a lower life expectancy than women in the country. Doesn't mean we have to go first, but just going statistically here. When the husband passes away, the life insurance proceeds go into the trust. Now, unlike a typical ILET, the funds do not then get distributed to the children or the grandchildren, whomever is the beneficiary of the ILET. Instead, they're held within the ILET itself with HEMS provisions for the surviving spouse. So now that life insurance isn't being given away. It can be used there for the surviving spouse in case anything goes wrong with her. And there are protections depending on the state you're in. You have to check your local state jurisdictions from Medicaid because it's a third-party trust. And when those assets ultimately end up going to the children after the surviving spouse passes away, those assets will be estate tax-free. So you get the benefit of all worlds here. You have money available to the surviving spouse. You have money that potentially can be protected from Medicaid. And you have money that goes estate tax-free to the beneficiaries. And all the while that surviving spouse is alive, that money is invested in growing and creating more funds for the ultimate net estate of both the husband and wife after they finally pass away that go to the beneficiaries. It's a great planning tool that can be used. And again, you got to have that third-party trustee in charge so that the surviving spouse doesn't have access to that money to create that wall of separation between the trust and the spouse. Medicaid trust. Depending on the state that you're in, you may not be allowed to be the trustee of your Medicaid trust. If your state allows Medicaid trusts, you, in a lot of states, are not allowed to be the trustee. Now, you need to check your local jurisdiction. So in this point, now you've got to look at who else is going to be the trustee of that trust. Okay? A lot of states allow children. Maybe if you fall into that situation that we were talking about earlier, why you may not have your children involved, you may want to be looking at a third-party trustee. Special needs trusts. A special needs trust, remember, does not have to just be for someone who has developmental issues. It can also be for people, and I'm just using as examples here, who have dependency and or spending issues. Remember, a special needs trust is a great way to preserve benefits that are now or potentially in the future. So, John, why don't I just have a family member be the trustee of this special needs trust? Well, there's a lot of reasons, and a lot of them come down to what we've already talked about. If there is a special needs trust, that can be a huge burden on the family member. More often than not, I find the sibling like, yep, I'll be the trustee for my sibling. I'll take care of them for the rest of their life. And then they're 5, 10 years into it, and they're just getting badgered by that sibling to give them money all the time. Give me more money, give me more money, give me more money, which comes down to number 2, the buffer, right? You don't have those siblings going at each other. You don't have that sibling who maybe is the spending issue sibling or the dependence issue sibling going after the other sibling who is the trustee. By having Legacy Trustee Services being the trustee of this, it creates that buffer so that beneficiary can call Legacy, and if it's not what the parents wanted them using for, then the money will not be used. So it creates that greater harmony. And then that beneficiary special needs trust, guess who they're going to probably go complain to? The other sibling. Those jerks over at Legacy, they won't give me my money. And the other siblings doesn't have to tell them that they agree with them. They're sitting there going, yeah, those guys are a bunch of jerks. But keeps that harmony within the family. And yeah, you're paying a little bit for it, but that small amount is far worth the harmony of those siblings keeping a stable relationship than it would be where that thing falling apart or the burden on that surviving sibling. Because if you are in a special needs trust that is for a developmentally challenged person, that surviving sibling is already probably going to be taking on a lot when the last parent passes away. Do we want to put them with a larger burden? Okay. And the third issue why you may not use family and you would use Legacy is understanding of benefits. All right. With the understanding of benefits, Legacy Trustee Services or another third-party trustee knows what to do with that money, how to invest that money to maximize it according to the creator of the estate's objectives for that beneficiary. And then you have IRA trusts. Now, with the Secure Act, lifetime stretching of IRAs became very difficult. And obviously, Secure Act 2.0 has its final implementations at the end of the year. But remember, there is still stretching with IRAs. May it be a lot shorter period of time, 10 years. And if you have clients who have younger clients who may blow through the money or take an IRA as a lump sum distribution as opposed over the 10 or 11 year period, you may want to have a third-party trustee to regulate that money coming in and out so it's not being taxed at a higher rate. Again, minimizing taxes, maximizing exemptions. So, what typically happens when your client dies? Well, to the client, to you, both your hard work and everything you've done with your client, you've grown their portfolio, right? You've worked with that client. You have a fiduciary relationship, but you probably, in most cases, have developed a personal relationship if you've grown this estate with them over their entire life, okay? You've been the one working with them to grow the portfolio. And what typically happens, right? Well, now by the client's wishes, those funds now go to their heirs. And now those assets that you have grown and you have serviced, right? They're going to go to another financial planner. Why should it be that way? Why should the assets that you have grown go to another financial planner, right? Your clients wanted you. They trust you as your financial planner. What is your client afraid of? Well, they're afraid of their kids' creditors, their kids potentially getting divorced, bad investments, even themselves, right? They want you to be the person still in charge of it. At Legacy Trustee Services, when a client refers somebody to us, we keep them with their financial planners if they're a multi-generational trust. That money is not going to go into an investment firm. Again, we don't do investments. I don't hold money under Legacy Trustee Services in my own brokerage, as a broker dealer with Charles Schwab. We don't hold money. We manage the estate. We organize the estate. We do the true jobs of a trustee. and let you, who initially grew the estate and worked with the client, retain the control for your client. Okay? So especially in these situations, it's important because you don't want those funds disappearing. A lot of clients nowadays are worried about their kids losing their money and blowing it. Legacy Trustee Services and a third-party trustee can definitely help eliminate that. So in conclusion, Legacy Trustee Services will help your clients. Okay? It'll also help you with client retention. Right? I don't want to be clients of Legacy Trustee Services lawyers. Okay? I'm their fiduciary. I am their successor trustee, the administrator of their estate. That's what Legacy is for them. Legacy is not their attorney. Legacy doesn't want to be their attorney. They want to administer the estate so that they are protected. As a fiduciary for a client, it's one of your jobs to educate your clients about these options when you're talking with them. Or educate your attorney partner or speak with your client's attorney partner with them on a plan and the person in charge. Managing that meeting will keep the client's assets safe for their heirs for generations to come. So that's all I really have for Legacy Trustee Services and third-party trustees. I don't know if anybody has any questions, but if they do, they can ask them now. And if not, I will pass this back on over.
Perfect. So far, I don't see any questions. I do want to just take the time and say thank you, Jonathan, for joining us today and speaking on this, and thank everybody else who joined the live stream, as well as anybody who watches it later on. And thank you, Jeff, for joining in to help with the technical issues earlier. And then we'll just give it a moment here just to see if any questions trickle in, and then let everybody know that I'm looking forward to seeing them next week, who is going to the event in Tennessee. And then I did see one comment just came in from Emmeline, and it says that this was excellent information. Thank you.
Thank you. I'm glad you enjoyed it, Evelyn.
All right, I'm not seeing anything else coming in. Emmeline said she did take notes, so that is great information, and it will be available within the next day or two on our YouTube channel and on our website for anybody who wants to rewatch it or go through in the future. All right, thanks everybody again for joining, and have a great rest of your week.
Thank you very much.
Thank you.